Hi everyone, and welcome to the Progressive Legal Workplace Essentials webinar for the hair and beauty industry. My name is Carla Vinciullo. I'm a special counsel here at Progressive Legal, and with me today is Claire Mould, one of our senior commercial lawyers.
Hi everyone, welcome.
Claire specialises in commercial contracts, trademarks and IP, all that juicy stuff. My area of expertise is HR and employment law, which is obviously the focus of today's webinar. But Claire will be hosting with me today because she will have lots of fantastic insight.
So I'll be asking lots of questions.
Lots of questions, which is fantastic. So look, if you are wondering, what is Progressive Legal? Let me quickly fill you in. Yes, we are a law firm. No, we are not scary. We pride ourselves on working with sole traders, small businesses, entrepreneurs, startups, and really getting to understand you and your business and what you need, and tailoring our services to that, don't we, Claire?
And we have a lot of clients who are salons in the hair and beauty industry. So we really know you guys. We understand the issues that you guys face, which is why we wanted to provide a tailored webinar for you. We're just going to bring up the slides so we can get the ball rolling. I'll just quickly say, though, by way of disclaimer, just be mindful that all the information that we're giving you today is intended for general information only. If you need our specific our help on a specific issue, please get in touch.
Absolutely.
Okay. Slides, minor technical issue.
Here we go. All right, so you should now be able to see our lovely slides, and Claire just ran through the disclaimer. So let's talk about what we are going to be talking about today. Look, we've only got a really short period of time, and I'm not going to try and cover absolutely everything, just the critical things that pertain to your industry. I want to talk about the industry audits. I want to talk about how important it is to know the law that applies to you and your business and to comply with it. So we'll talk about the Fair Work Act, and we'll talk about the award. We'll talk about contracts of employment, why they're so important to have written contracts of employment. We're going to focus on restraint of trade. So people not stealing your clients, people not stealing your staff, interfering with your business.
It's a common issue.
It's a really common issue, not going into competition with you. And I'm going to end with some top tips.
Lots to cover, lots to cover.
So look, I want to talk about this industry in particular because, look, the reality is there's just a really high level of non-compliance in the hair and beauty industry when it comes to complying with workplace laws. I'm not making this statistic up, am I, Claire?
No, I heard about this. It sounded a little invasive and a little scary, but we're not here to scare you.
We're not here to scare you, but look, in 2013, the Fair Work Ombudsman tabled a national hair and beauty campaign. What that basically means is that the Fair Work Ombudsman, a little bit like the COP for the workplace relations legislation, went and randomly audited several businesses throughout Australia in the hair and beauty industry, literally knocking on doors saying, do you give pay slips? Do you have written contracts of employment? All of those curly questions that might freak you out a little bit. Look, basically the report was pretty damning, wasn't it, Claire?
Yeah, it was.
So 55% of audited businesses were breaking the law. They were non-compliant with the award. They were breaking it. They were not doing what they should have been doing.
And so just to recap, what do you mean by non-compliance?
Okay, so different types of non-compliance. There were money breaches, so, underpayment of wages, which is a very serious issue. And then what I would
So not paying people the right amount.
That's right. Or not paying them at all for certain things, like certain allowances and things like that.
Okay.
So the other issue when it comes to non-compliance is more technical breaches. So perhaps not issuing a pay slip within the first day of receiving your pay. So no one loses any money, but it's still not right. So there's non-compliance in that regard.
So you have to send a payslip on the first day.
Within 1 day?
Within 1 day
of being paid.
Okay.
That's right. So many people don't know these things. And look,
I didn't know that.
And that's why we're here to help. So like this next slide says, guys, be alert, not alarmed.
Are they still doing these audits of the hair and beauty industry?
The audits are ongoing. Yeah, they are ongoing. Okay. So the audits started in April this year. They will go for 12 months, so through until April next year. And in that time, they want to target 1,600 hair and beauty salons in New South Wales, Victoria and Queensland.
Gee, that's considerable. So I guess what all salon owners probably want to know is what can they do to give themselves the best chance of standing up and in an audit situation? How can they be compliant?
Yeah, exactly. Well, look, you don't know what you don't know. And I really do think that the number one thing is if you don't know exactly what to do, put up your hand, ask the question. It's so important. No one expects you guys to be lawyers and to know all this stuff. But if you know that there's a few questions that you've got lurking in the back of your mind, put up your hand, ask the question, give one of us a call. So look, you've got to play by the rules. To play by the rules, you need to know the rules. Look, at the top of the compliance pyramid is, like I said, the Fair Work Act and the National Employment Standards. So that applies to most PTY LTDs and sole traders throughout Australia with a few exceptions. If you're in WA and you're a sole trader, you're possibly not covered by the federal jurisdiction, so the Fair Work Act. So give me a call if you want to talk about WA state coverage. But at the top of the pyramid is the Fair Work Act and the National Employment Standards, like I said. So these are the general rules of play that apply to everyone. So things like 4 weeks annual leave for full-timers, 10 days sick leave, all of that kind of stuff. The next rung down is the Hair and Beauty Industry Award. That is your industry-specific go-to terms and conditions of employment. That talks about you guys, your hours of work, the times that, your shop can be open, when you need to send rosters out, all of that kind of stuff, industry-specific. It's as good as law. It's as powerful as legislation, so if you break it, it's a problem. And then sitting under all of this is your contract of employment, which might be verbal, it might be written. We always encourage a written contract of employment. Okay, it's super important.
Otherwise you end up in a he says, she says situation.
Yeah, it'll be, I was promised this and you've got no proof. You've just got no proof to support what you're saying. And it gets messy. So look, one thing I really want to make clear here is that your contract of employment really needs to be consistent with the Hair and Beauty Industry Award and the Fair Work Act and the National Employment Standards, okay? So it can't undercut. You can't undercut what the award says.
So, as you say, you need to be compliant with the Fair Work Act and the award. So if you're a salon owner, it'd be pretty risky to just, go online and look for an employment contract online and download it and use that because, while it may be compliant with the Fair Work Act, but it's not necessarily going to be compliant with your relevant award in your state. So it's...
Absolutely. I've seen contracts of employment downloaded from the internet. There've been, bits of UK law, bits of US law. I've seen Australian contracts of employment that have come from online or, someone's given it to a friend who's starting their business, but it's like 5 years old and says a bunch of stuff that's really unhelpful. So like a really big one that I see is we have this concept, it's super important, called 38 ordinary hours of work a week for a permanent employee. Now, even though I know a lot of people work a lot more than that, can be a real problem to say in your contract of employment 40 or 45 ordinary hours a week. That's why it's so important to speak to a lawyer, because you need to know how to draft these things so you don't get in trouble. If the Fair Work Ombudsman does come knocking on your door, you don't have to say, oh, I just got this contract online. It's, sorry, it's not very good.
Exactly. You don't know what you don't know. It's important to get help. Otherwise, the contract that you use, that you pulled up from online, might not be worth the paper that it's written on.
And it might even just get you into even more trouble than you were in the first place. So look, There's a lot that you need to know about your industry-specific award, okay? And by no means are these 5 things all that you should know. But these are the things that I always see coming up for the hair and beauty industry. First of all, people need to know if they're a part-timer, a full-timer, or a casual. It really should be written down on the contract. They need to know. You can't hedge your bets.
Even if it's your friend, even if it's a member of your family.
Absolutely. Fair Work Ombudsman doesn't care if you're not complying, but the person's your mother or your friend. They don't care about that. Part-timers. There are lots of part-timers in this industry, okay? Part-timers are wonderful. I'm a part-timer. It's great. Employees who are part-time work less than 38 hours a week, okay? If they work 38 hours a week, guess what? They're a full-timer. So
really?
make sure you get it right.
So even if your contract says that you're less than 38 hours, if in effect you are doing more than that?
Well, this is an interesting question. So if the contract says you work 24 hours a week in this industry, but someone ends up working more than that, guess what? Unless your contract's drafted really cleverly and carefully by a lawyer, that's overtime. There's so much to know, guys. Okay. There's so much to know.
Let's not get bogged down.
We won't get bogged down. With part-timers, it's so important to have certain things agreed in writing. We need to know what their regular pattern of work is. So it needs to be in the contract of employment. What are their days of work? What are their start and finish times? It's so important. If it's not written down and given to them, i.e. in a contract of employment, you are breaking the law because you are not complying with the award. It's so important. Same rules apply to classifications, okay? So someone might have a job title in your business. They might be your receptionist. They might be your senior colour consultant. That's amazing. But you need to tell them in writing what their job is classified as under the award. So a level 1, a level 2, a level 3, level 4, 5. You need to check the award, check the classification, look at their qualifications, and come to a decision about what their classification is and let them know, okay? It's so important. If you need help with this, again, this is all stuff that I can help you out with. I've done it so many times before.
You've been doing this for about 13 years, haven't you?
Been doing this for about 13 years, yeah. So, look, rosters, you've got to notify your part-timers and full-timers at least 2 weeks ahead of time what their hours of work are going to be. Now, you might be thinking, but your part-timers have set hours. Yep, they absolutely do. But you do have the capacity to issue rosters with appropriate notice. And, the award realises that the industry's got to be flexible, okay? So with the flexibility, that's fine, but you need to give 14 days notice.
I like this next one.
Annual leave loading. Everyone doesn't sort of tend to realise that when someone takes annual leave, so obviously you're permanent, so your full-timers and your part-timers, on top of what they would ordinarily be paid, add 17.5%. Unless, of course, you have paid your employees a very, very big, nice and fat above award hourly rate of pay, which already builds this in, okay? But again, you can't just rely on that unless your contract specifically says what is and isn't built into that rate of pay. Does that make sense?
It does, yeah.
Okay, perfect. It can be all a bit much, but we're here today to try and keep it really simple. So, pop quiz. Claire, I'm going to ask you, okay, which type of contract do you think is the best and easiest to enforce? A, no contract. B, verbal contract. C, partly verbal, partly written. Or D, a full written contract.
Full written contract.
Congratulations.
Thanks.
You are a winner. Who wants to be a millionaire? Look, we're having a laugh, but it's so important because the number one question that Claire asks in her role and I ask in mine when someone says, I've got this issue, we always say,
what does the contract say?
What does the contract say? So look, contracts of employment should really cover off on the type of employment. So it should say, is your staff member a casual, a permanent, or a full-timer? It should say what classification the person is. It should say what their hours of work are, their days of work, what time they start and finish. So the expectations are really, really clear. It should say their rate of pay. It should say any applicable allowances. and drilling down on that point, it should say what is and isn't built into that rate of pay, all right? So if you're building in your annual leave loading, you've got to make that clear. Otherwise, you're going to need to pay it as an extra in circumstances where you're already paying a really generous rate. So you've got to bear all of this in mind. Post-employment restraint clause, okay? Really important. If you don't have a clause in your contract that says you can't go up and set up shop next to me 2 kilometres down the road and you can't steal my clients, you won't have much of a leg to stand on. Confidential information, social media and set off are also really important, okay? You've got to protect your brand, so you've got to make sure that everybody knows the score. You can't pinch my confidential information. You can't pinch my photos of hairdos and makeup styles from social media. Set off is a legal concept, okay? We won't get into that today, but there are lots of really technical legal clauses that might seem really boring to you, but will protect you if push comes to shove.
Yeah, nice one.
All right.
Restraint of trade. This issue comes up a lot. I think last week someone called me and said, Claire, I've had this girl working for me for 3 years, and I've just found out that in the background she's been working on setting up a competing business. So what can I do? And obviously, first question I ask is, what does your contract say? She didn't have one.
If you don't have a contract of employment that has a restraint of trade clause, so what I mean by that is something that says, you can't steal my customers for a period of, 3, 6, 12 months.
Whatever's legitimate.
Whatever's reasonable. Yeah, and I'll get to this concept of reasonableness in a moment. But if you don't have anything written down that says you can't pinch my staff, you can't pinch my customers, you can't interfere with my suppliers, and you can't directly compete with me in a substantially similar business, you won't have much of a legal leg to stand on, because you will be trying to go down to court and say, hey, that's just not fair. And guess what? That argument just won't get you very far at all, okay? So the reality is, if you don't have a clause in your written contract of employment, forget about it. It might sound harsh, but it's just true. So what you need to do is you need to get an appropriately drafted clause into your contract. Now, this kind of clause is a little bit controversial in legal circles, okay? Because people have the right to go off and earn a living, but you also have a right to protect your brand, and it's got to be this beautiful counterpoint and balance between the two, okay? So the legal position really is these sorts of clauses are only enforceable if they are reasonably necessary to protect your brand, to protect your business interests. If you're doing it just to be painful or difficult, or if it's just not fair because the person was a casual, for example, it's not going to work.
I remember one time someone drafted their own clause and it said, so-and-so cannot set up a competing business anywhere in the world ever. And that kind of thing obviously wouldn't be enforceable. So bottom line is, don't try and draft your own.
No, there's a really, and look, there's a really, really technical way of drafting these types of clauses.
The cascading.
It's called a cascading clause. Think of a lovely cascading waterfall.
I think this will bore them.
It will.
Yeah.
So what I'm going to say is this.
Not that you're boring.
You come and talk to us about how to draft it, because the bottom line is no one expects you guys to do this stuff. That's our job.
You do what you're good at. We do what we're good at.
Social media is such a big issue. Look, Claire and I see this all the time, don't we?
Yeah.
It becomes really important with restraint of trade as well, guys. So what I see a lot of is hairdressers resigning, leaving your business, and then you find out a couple of weeks, a couple of months later that they've got a really nice Instagram page, and look at that. They're photos of hairstyles that person was doing in your salon.
On your watch.
On your watch.
Being paid by you.
And they're holding these photos out as being work they're doing for their new business, their new brand. Again, you can write to them and you can say, look, please stop that. But if you don't have a written clause in your contract of employment, it's just that little bit harder, okay? So look, I really encourage you to do a couple of things. These are my top tips. The first one with social media is really don't, to the extent that you can, try and get all the photos of your hairstyles, your makeup, your treatments, all on one device that you control, such as your iPhone or your iPad for the salon. So you've got some control over the actual photos.
That's a really good idea.
So I know a lot of businesses let, the staff take photos on their phone and then upload them, for example, to the salon's page or the clinic's page. I'm not saying that that's wrong, but what I'm saying is you start losing control over your confidential information, over your photos, and then it raises this question, which is, well, were you kind of letting them use the photos for whatever they want? It's just really important to put some parameters in place. And I can help you with this with a social media policy, a code of conduct as well. You don't need to have all of this stuff in your contract of employment as well, guys. You can have some really easy to understand, really basic, fundamental golden rules for your business. So, look, I want to talk about some 5 key takeaways.
Yep.
I know that I've said this time and time again today, but I'm going to say it again because I just want to make sure that you guys understand how important it is to have a legally drafted written contract of employment. There are a lot of HR shysters out there, aren't there? There are. So look, someone who's in HR, someone who just does contracts and policies, and who isn't a lawyer, guys, they don't necessarily know all of the ins and outs with the award and the Fair Work Act and the Restraint of Trade and stuff like that. They'll only know the real basics. And I'm not saying that there's anything wrong with that. They have their place. But you can't rely on it from a legal perspective. If they get it wrong, you can't sue them. You can actually sue lawyers if they get it wrong because we're held to a higher standard. If you do have contracts in place, that's fantastic. But I really encourage annual reviews as a minimum, okay? It's
Absolutely.
Really important. And look, reviewing things annually is also super important around the time of the end of fin year because that is also the time when the modern award is usually subject to a rate change, okay? And that's when all the minimum rates, quite often every 12 months, are subject to the Fair Wage Review. And they increase. So last year, I think they increased by 3.3 or 3.6%, something like that. So I told all of my clients before 30 June, get ready, rates are going up. Now you might, you might need to review your contracts around then because it might have an award rate. I spoke about those award must-haves. You've got to get all of those into your contract. So you've got to make sure that the content reflects the award as well, okay? And like I said, get your post-employment restraint clauses into your contract. So if you do want to go to court and defend your business and your brand, you can. You've got a contract to point to.
Absolutely. And if in doubt, get advice.
Get advice. Get advice, guys. Don't rely on what friends say. Don't rely on what the Fair Work helpline says, okay? Half the time they're not lawyers. They might have been operating off wrong advice themselves. Look, it's always good to listen to other people, their experiences, their stories. But if anything I've said today has got you thinking, has got you worried, has just, given you a little inkling of, it's probably time I just, check my documents, there's no time like the present. I always say a stitch in time saves 9. If everything is going awesome for your business right now, this is actually the perfect time for you to not rest on your laurels before Christmas and, or any time really, and just check your documents, check where you're at.
Because if you're one of those 1,600 salons that get investigated, even just the simple act of putting up your hand or sending an email to Carla, booking in a strategy call, shows that you've taken steps to, make sure you're compliant. It's showing that you're taking a step in the right direction.
And so, look, if you're thinking, how much is all of this going to cost me? I can't afford it. We hear you. We hear you loud and clear. And we operate really differently to standard law firms, okay? The first point I want to make is that you are welcome to have a completely complimentary, obligation-free strategy call with me. I will give you my time for nothing over the phone and get to know you, your business, and where you're at, and talk to you about how I think I may be able to help you. That conversation will be privileged and confidential, and if it goes nowhere, that is completely fine. If it goes somewhere, one place it may go is to a legal shield package. So we understand that cash flow is a real issue for small businesses, and that you might not have,
a few grand sitting in the bank.
$2,000 just sitting there. We get that. So we have worked out what the cost or the value of our services would look like, and we apportion it out over a monthly cycle. So like a gym membership kind of concept, right?
Yeah.
So we have a really special offer just for the hair and beauty industry. The first 50 people, is it 50? 50. The first 50 people that ring up and say, I want legal shield for salon owners, will get 24/7 access to Law in a Box. That's all our really great online content, fact sheets, things that will really help you. You will be able to call us 24/7 and we'll give you legal advice. Well, maybe not 3 o'clock in the morning, but you will be able to call me anytime on my mobile phone and ask me any questions you have about HR, employment, anything at all. Claire will be able to speak with you about your intellectual property, your social media, your commercial contracts, disclaimers, and the kicker is I will draft you a tailored contract of employment for your business, suited and tailored to your business. That is amazing.
It is amazing. So for only $154 a month, oh my gosh, I sound like I'm selling steak knives. It's
better than that.
$154 per month for 12 months. So it's a minimum 12-month commitment, because obviously these things do take time. Yeah. And but yeah, for that amazing price, you get all of the above.
And look, if you're thinking, but I've got a contract of employment, I hear you loud and clear. So what I will offer you is a full comprehensive review, and if no amendments or tweaks are, legally required, I will help you in some other way. If you need an independent contractor agreement,
I'll waive the disclaimer,
or a code of conduct, a social media policy, I am happy to be flexible and work with you. I just want to see people comply. Claire and I love what you guys do in your industry. We're big consumers. We see the value in your services. We get that you're busy and we get that you don't have time for this stuff. That's our job. That's why we're here to help. So look, thank you so much. Here's our contact details. My mobile number's there. Claire's is too. Our email addresses are our first names, followed by @progressivelegal.com.au. If you want more information about the firm, about us, about all the other packages we have, because we have so many great ones, head to progressivelegal.com.au. Thanks so much. I hope you all have an amazing day.
Bye, everyone. Thanks for joining.